This is a country with a lot of culture war conflicts about the role of religion.
Religious groups and religious communities challenge our thinking. Society assumes things work one way, and then you have this religious group saying, no, actually it works a completely different way. And I think it forces all of us to think about that and ask hard questions.
In Wisconsin, there's a general law requiring people to send their children to school until they're 16 years old. And in the 1960s, the Amish community in Wisconsin wanted to take their children out of school at 14.
And now the question is, do they go on to a big public high school, or can they stay home and learn on the farm?
In some ways, it seems odd. This looks like a little case. It's a few people. They're fined $5 for not sending their children to school in a little county in rural Wisconsin. It winds up being a big deal in the Supreme Court, and we're still talking about it. This is a story about the Amish community. It had been around in Europe and then the United States for hundreds of years, about the values they represented, that they were farmers, that they were committed to the idea of a simple agrarian life.
Their religion pervades every part of their life. You know, when I would go to meetings with the clients, we would drive, and I would drive past buggies on my way there. And then the men would come in for the meeting, and they were all wearing the same clothes. They all wore blue. It was button-up shirts, no zippers. They all had these straw hats that you took off and hung on a peg because you didn't wear your hat indoors. For them, that's actually a religious practice. That's actually a way that they say, we are distinct from the rest of the world. We belong to this community, and these are the rules we follow.
The Constitution obliges the government to respect those religious convictions and attitudes. The Bill of Rights starts with Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof.
One of the big controversies in interpreting our free exercise clause and our constitutional protections is, what does it mean to have a generally applicable law?
There's a difference between a law that targets religious belief or targets religiously motivated conduct and a law that is general and applies to all the conduct that it covers, whether motivated by religion or not. Think about the difference between alcohol prohibition across the board and prohibition of the use of wine in Christian communion, right? That would be a targeted law. And of course, a law that targets religious practice, we'd say this is going right at the free exercise of religion. A generally applicable law may have an impact on the exercise of religion. It's not aimed at it.
What do you do when a law that's supposed to apply across the board hurts somebody's religious exercise? Does that person get an exemption from the law? And when do they get that exemption?
And that's what Wisconsin versus Yoder is about. Whether the free exercise clause, as applied to that community at that time, requires an exception to the generally applicable requirement that children go to school until they're 16 years old.
It is surprising that this case went all the way to the Supreme Court. The Amish don't like to go to court. They're pacifists, and they see going to court as kind of a fight.
There was a local Lutheran minister, and he contacted a fellow named William Bentley Ball, who was a professor at Catholic University, who cared about religious freedom, who had written about it, who had argued cases in the Supreme Court about it, and brought Mr. Ball in to represent the 3 Amish parents who were charged with truancy with respect to their children in the Wisconsin public schools.
William Bentley Ball is not Amish himself. He was Catholic, and I think he really helped to pioneer some of these ideas in some of the areas that we're still working in today, recognizing that the Supreme Court needs to protect religious communities, needs to protect religious exercise, even when it looks a little bit different from the rest of society.
Mr. Ball, quite wisely, instead of just saying, well, we have a religious belief, he brought in expert witnesses to talk about the history of the Amish, their religious convictions, their experience in Europe and in the United States, as well in Wisconsin in particular, their educational values, the role of vocational education in the way they treated their children.
The Amish have a practice of educating their kids through 8th grade. They want them to learn reading, writing, and arithmetic. And then after that point, they're still teaching the kids, but they're teaching them on the farm. They're teaching them about the hands-on work that they're going to be doing as adults and for the rest of their life.
So it wasn't just, oh, this is our free exercise rights, leave us alone. It was a deep account of what those religious convictions were and how they affected their community.
Wisconsin's big argument here was that education is one of the most important things the state does. You need to be able to educate your children to be good citizens and contribute to society. And I think that's something that we're all sympathetic to.
The state does have an interest, a strong interest, in making sure its people are educated. But there had been earlier cases in the Supreme Court in the 1920s, general cases about parents' rights and education, which put some limits on the state's power to control education. So this was already in the law by the time Wisconsin versus Yoder came up.
And the Supreme Court said that although Wisconsin had some very important interests in play here, those did not overcome the interest of the Amish parents in being able to direct the religious education of their children.
The Amish win. Yoder and the other parents win. And they say the state cannot force these parents to send these children to school after 14 years old.
The Supreme Court recognized that this was a religious way of life, and it could actually destroy their religious way of life if they were required to send their kids to traditional high school.
And the court did not emphasize the parents' rights aspect of it. There was much more emphasis on the free exercise of religion. There was a tremendous emphasis on the Amish community. This wasn't some sort of narrow, particular parent, particular family, I want my kid out of school kind of story. No, this is a kind of special case. It's not only religious, but it's shaped by this kind of depth and history and commitment of the Amish community.
I think it is both a free exercise case and a parental rights case because it's the place where these two things meet. What are the rights of parents to be able to decide about the education of their children, and how is that impacted when you're talking about religious beliefs and a religious community? The Amish definitely don't see those as being two separate things, and I think the Supreme Court in this case recognizes here they weren't two separate things, they were one thing.
Warren Burger, who was the Chief Justice of the United States, who looked the part, right? He had sweeping white hair. I would say he looked it better than he played it. He wrote an opinion that in one way looks narrow because it emphasizes the history of the community, but in other ways it looks very broad because it talks about religious exemptions from general laws. It introduces that into the constitutional law for the first time, where then it has a life of its own.
I think that Yoder was probably kind of the peak of free exercise exemptions. After that point, we saw a series of cases that tended to make the standard a little lower, a little lower, a little lower.
In the next 20 years after Wisconsin versus Yoder, whenever other free exercise claimants show up in the Supreme Court and say, we want an exemption from some generally applicable law, and they cite Wisconsin versus Yoder as being on their side, over and over and over again, the Supreme Court finds a way to say, nope, this case is different. This one is different.
The Supreme Court found different reasons why. They thought the government had a really strong interest. They thought the law really applied across the board. They thought there was some other reason that the case was different than Yoder, and so they didn't have to apply the Yoder rule.
So Wisconsin versus Yoder turns out to have what I might describe as no generative power. You know, sometimes cases change the law, they lead to something that then develops over a whole series of cases thereafter. That's not what happened with Wisconsin versus Yoder.
We're now sort of going the other direction today. I think the pendulum has swung back, where the courts realized, wow, we didn't do a good enough job of protecting religious exercise. Maybe we need to look at some of these laws with a more critical eye.
Wisconsin and Yoder may play an important part in this case, in Mahmoud versus Taylor.
Mahmoud v. Taylor is a case that's before the Supreme Court right now, and it's about parental rights and religious freedom in Montgomery County, Maryland.
The county put in its language arts program, kindergarten through 5th grade, some material about racial differences, religious differences, but also identification of LGBTQ characters and themes.
The Montgomery County School Board has required that teachers include some pride storybooks in their regular classroom education starting from 4 years old up through 5th grade.
These were not stories about sex people having sex with each other. These were stories in which, for example, you might have a prince falling in love with a knight, okay? There were two men who were interested in each other, that sort of thing. There was a pride parade and a puppy chasing a ball in a pride parade. This is the way of introducing children, kindergarten through 5th grade, to some themes about diverse people in the world.
This was something that was new. Generally, those issues were taught about later on in middle and high school previously. And there were a number of religious parents in the community, Muslim, Ethiopian Orthodox, Catholic, and other religious groups who were very concerned about this and said this is contrary to our religious beliefs, what we're teaching our children, and when we start to teach our children about sensitive issues around gender and sexuality. The parents in Mahmoud asked for a really simple thing. They weren't asking to get rid of them. They just wanted an opt-out.
And for a very brief time, the county went along, and then as the numbers of people making this claim increased, they said, wait, no, this is a mistake. This is a diversity curriculum, language arts, diversity, and we want everyone to read these books, and because we're going to have a problem managing all these children in the hall and trying to find an alternative program for them. So there was a lawsuit about this, where the parents who were refused the right to notification whenever one of these books was read, the right to opt out.
Yoder is really the lead case that's being argued about in Mahmoud, because there's this question of you have religious parents who have certain understandings about education and how they educate their children, especially on sensitive issues like sexuality. We just want the right to be able to opt our children out of certain lessons that are contrary to our religious beliefs and teach them about those beliefs at the right time and at the right age.
In Mahmoud against Taylor in the lower court, Wisconsin and Yoder is a centerpiece. But it's mainly with the lower court judge saying, well, this case is not like Wisconsin versus Yoder, because that was the Amish community. They've been around for hundreds of years. It was only ages 14 to 16. The Amish were educating them in their alternative ways. That was different. These are young children. The county wants to expose them to certain ideas. The county has authority to control the curriculum. And so this is not like Wisconsin versus Yoder.
The parents in Mahmoud all along have said, no, this case is just like Yoder. This is about our right to be able to direct the religious education of our children.
So we will see whether Wisconsin and Yoder will have legs in this case. I think the court is going to be very careful, whatever it says about who wins or loses in Montgomery County. I think they're not going to want to invite parents generally to be able to opt their children out of particular books and particular readings. Could be highly disruptive. I think that's a reason for the county to win this particular case. But even if the county doesn't win this case, that's going to be a matter of general concern.
I think it's going to be a crucially important case because this is the first time that I can think of since Yoder where we've had this exact question before the Supreme Court. What rights do parents have over the religious education of their children? Is Yoder still going to be applied with force today? I think the most important thing to recognize from Yoder is that America does respect religious freedom of different religious communities. That's actually something that makes our country stronger, and Yoder is a great example of how that can work.
There's a narrative about religious freedom in the United States. It goes back before the Bill of Rights. It includes many pieces. Wisconsin versus Yoder is an important piece, partly for what it holds and its protection for the Amish, but also partly because the court then doesn't follow it as aggressively as it might. The ups and downs and the twists and turns are complex and many. Wisconsin and Yoder is a very important part of the course, but only because it plays a significant role in this larger narrative about religious freedom in the United States.